Welcome to the Deep Dive. Today we're tackling a really significant piece of legislation. It touches on economics, public health, even just everyday consumer responsibility. We're talking about the Liquor Act 59 of 2003.
That's right, a foundational law.
Exactly. And our sources show it's been around, well, nearly 2 decades now, assented way back in April 2004. But here's the thing. It's not some dusty old document. It's still actively managed. I saw this updated just last year, August 2023. So our mission today is to really unpack this, understand its structure, its purpose, and what it actually means in the real world for everyone involved.
It's a fascinating piece of law because fundamentally it's trying to do two quite different things at once. It's a bit of a juggling act. Its stated purpose, right there in the text, is first to set up national norms and standards. The idea is to keep some economic unity across the whole industry. That's the business angle.
Okay, the business side.
But then, just as importantly, there's the social responsibility side. The Act explicitly aims to reduce the socioeconomic and other costs of alcohol abuse. So it's this constant tension. Regulate a very profitable industry while trying hard to minimize the harm its products can cause.
That dual mandate really jumps out, doesn't it? Almost like a carrot and stick approach built right into its core. When you look at Section 2, where it lists the objects, that tension is crystal clear. On one side, yeah, it's about social responsibility, setting national rules for making it, selling it wholesale, and even setting the norms for how provinces handle retail sales.
Exactly. And then you flip the coin, and there's this very clear focus on economic development, too. The Act talks about promoting a responsible and sustainable industry. And it's not just talk. It links this to concrete goals, like getting new people into the industry, promoting diverse ownership, which is a big one, and making sure the whole sector kind of operates with this awareness of social responsibility. Basically, if you want to grow your business in this space, you have to show you're contributing positively on the social side, too.
Okay, let's talk specifics then. Jurisdiction. This must trip people up all the time. If you, the listener, own a liquor business or maybe want to start one, where does this national act stop and the provincial rules take over? That seems critical.
It is probably the most common point of confusion we see. So this national act, the one we're looking at, it really focuses on the, let's call it the upstream part of the supply chain. We're talking about manufacture. That means actually producing the liquor or maybe bottling it with the clear intention to sell it later. And it also covers distribution. Now, in the context of this act, distribute means selling liquor to someone else who is also registered. Think like a wholesaler selling cases to a registered retail store.
Got it. So national handles the making and the wholesale side.
Largely, yes. Then the actual retail, the bottle shop selling to you or me, the end consumer, and also the regulation of smaller producers, the ones called micro-manufacturers. Those aspects are mostly governed by what the Act calls applicable provincial legislation. Each province has its own setup for that.
But the National Act still has a say.
Absolutely. It sets the essential minimum norms. So whatever the provinces do, their laws have to meet these basic national standards. It ensures a baseline level of control everywhere.
Okay, that clarifies the structure.
Yeah.
Now, before we move on, there was something in Section 4 that caught my eye. An exclusion. It says the act doesn't apply when someone sells liquor from their private collection. How does the law stop someone from just, running a side business and claiming, oh, it's just my private collection?
Yes. That's where legal definitions and interpretation become really important. A private collection is defined pretty clearly. It's liquor you bought for your own personal use without planning to resell it for profit. But the Act anticipates that loophole. Section 1, subsection 2 gives regulators clear guidelines to figure out your real intent. It's not just about what you say.
How do they do that?
They look at objective factors. How often are you selling? How much are you selling? Does it look like you're trying to make a commercial gain? Is there any evidence you're advertising or marketing it? So if you're selling cases of wine every week from your garage, the regulator is going to look past your claim of private collection and see it for the business it likely is. Your actions speak louder than your label, essentially.
Right. The law looks at the substance, not just the form.
Yeah.
Good point. Okay, let's shift gears a bit. Let's talk about the parts of the act that probably affect the general public most directly, the social guardrails, if you will.
Definitely. And the most prominent one, the one everyone probably knows in some form, is Section 10. That's the prohibition of supply to minors. It's straightforward. You absolutely must not sell or supply liquor, or methylated spirits for that matter, to anyone under the age of 18, full stop.
But there's always a but in law, isn't there?
Yeah.
There's a very specific, very limited exception mentioned.
There is. It's quite narrow. It allows a parent or an adult guardian, or someone who's administering a recognized religious sacrament, to supply what the Act calls a moderate quantity of liquor to a minor. But there are strict conditions. The minor has to consume it in the presence of that adult and under their direct supervision. It's really about parental rights or religious practice, not about letting kids drink freely or buying rounds at a pub.
And the responsibility for checking age.
Yeah.
That falls squarely on the seller.
100%. Section 10, subsection 3 is explicit. Anyone supplying liquor has to take reasonable measures to accurately figure out if the person buying is a minor or not. This is what we call due diligence. Just saying, oh, they looked 18 probably won't cut it if challenged. The seller needs to show they took active steps, like asking for ID, you know?
Okay, so age is a big one.
Right.
What else? Product safety comes up too, doesn't it? Section 6.
Yes, and this is crucial for public health. Section 6 tackles dangerous or fake products head-on. First, it says you can't sell something as liquor if it actually isn't liquor. That stops basic deception. More critically, it prohibits making or selling something the Act calls an impotable substance, basically. Anything unsafe for people to drink as if it were liquor. And you also can't add an impotable substance to legitimate liquor. This is the section that cracks down hard on dangerous, illicit home brews or people adulterating drinks to make a quick buck. It's about preventing poisoning, fundamentally.
And the social responsibility theme continues with advertising in Section 9. There are definite limits there.
There are. The rules focus on truth and responsibility. You can't advertise in a way that's false or misleading. That's standard consumer protection. But crucially, the Act specifically forbids advertising that's designed to target or attract minors. That's a clear line. The industry needs to market its products to adults responsibly, not try to hook kids.
Makes sense. And one more before we hit the registration process. Section 8 deals with employment. This feels like it addresses some older, potentially exploitative practices.
It absolutely does. You can't employ anyone under 16 in manufacturing or distribution unless they're part of a proper registered training scheme or learnership. And harking back to, well, frankly, abusive historical practices, the Act forbids giving workers liquor or methylated spirits instead of wages or as part of their payment or even as some kind of incentive to take a job. Pay must be actual money, not alcohol. It seems obvious now, but it was important to codify.
Okay, so we've seen the rules. Now, how does the industry actually get permission to operate? Let's dive into Chapter 3, the regulatory framework. If you want to be a manufacturer or a distributor at the national level, you need to register. And the Section 11.2 immediately lists who just can't apply.
Yes.
The disqualifications.
Right. These are the initial hurdles. You're automatically out if you're a minor yourself. Or if you're an unrehabilitated insolvent, that means you've been declared bankrupt and haven't legally cleared that status yet. Also, anyone committed under the Mental Health Act is disqualified. And very importantly for industry integrity, if you've been convicted for breaking this Liquor Act or related laws within the last 3 years, you're barred from registering.
Okay, so assuming an applicant gets past those basic checks, then the minister looks at the application based on Section 13. And this is where it gets really interesting policy-wise. It's not just about ticking boxes.
No, not at all. This is where the Act really shows its broader socioeconomic goals. When deciding whether to grant registration and under what conditions, the minister looks at things far beyond just basic compliance. They actively consider the applicant's commitments regarding Black economic empowerment, or BEE. That's a huge factor. They also look at what the applicant proposes to do to help combat alcohol abuse. This could mean things like signing up to voluntary industry codes of conduct or maybe funding awareness programs.
So it's almost like a social license to operate. The government is essentially saying, okay, you can have this potentially very lucrative registration, but in return, we expect you to actively contribute to transforming the market, creating jobs, and helping fix the problems your product might cause.
That's a very good way to put it. Precisely. They weigh the impact on competition. Will this new registration help or hinder it? Will it bring in new players, create jobs, increase the diversity of who owns businesses in this sector? Even things like potential for exports can be considered. It makes the registration itself a tool for achieving wider government policy objectives, not just a permit to sell booze.
And transparency seems to be a running theme, too. Once you are registered, Section 14 lays out ongoing duties like paying annual fees, but it also says you have to put your registered status and number on all your trading documents.
Yes, invoices, delivery notes, everything. It ensures traceability and accountability. And that transparency feeds into Section 23, which mandates the creation of a national record of registrations. The minister has to set up and maintain this register, Crucially, it has to be publicly accessible. That means you, as a member of the public or another business, should be able to inspect it, probably find it on a government website, or even get a printed copy if you pay a fee. It allows public scrutiny of who holds these national licenses.
Right, accountability through openness. Okay, let's move into segment 4. We've got the rules, we've got the registration process. Now, what about when things go wrong? Enforcement and penalties. Who actually polices this act?
The main enforcement muscle comes from inspectors. These aren't just any officials. They're specifically designated by the minister. And the act gives them significant power. It explicitly calls them peace officers in Section 25. Within the scope of this act, that gives them powers similar to police, like investigating complaints that come in, actively monitoring businesses to check for compliance, and importantly, seizing goods if they find violations.
How much power do they have to just walk into premises? Do they need warrants?
It's a structured approach. Generally, if they have a reasonable suspicion that the act isn't being followed and they need to search, Section 27 says they need a warrant issued by a magistrate, standard procedure for searches. However, Section 28 provides an exception for routine inspections at premises that are already registered under the act. They can enter without a warrant for these compliance checks.
So registered businesses are subject to routine spot checks.
Correct. But there's a limit to prevent harassment. Even these routine warrantless checks can't happen more than 6 times at the same registered premises within any 12-month period. Unless, of course, the owner consents to more frequent visits or the inspector comes back with a specific warrant based on new information. It tries to balance the need for oversight with the business's right to operate without constant disruption.
Okay. And if these inspectors do find illegal stuff like unregistered liquor being made or those banned impotable substances, they can seize it immediately under Section 26. But what are the actual consequences for the person or business involved? Let's get into Chapter 5, the penalties. And they seem pretty hefty.
They are designed to be a serious deterrent, no question. The Act distinguishes between different levels of offenses. For what you might call the major violations, listed in Section 35, 1A, things like manufacturing or distributing liquor without being registered, selling those dangerous and potable substances we talked about, or, crucially, selling or supplying liquor to a minor. For those, the maximum penalty is severe, a fine of up to 1 million rand or imprisonment for up to 5 years. Or potentially both.
Wow, R1 million. That's not pocket change, even for a larger company, and 5 years in jail.
Exactly. It signals how seriously these particular offenses are viewed. Even for the somewhat lesser offenses under Section 35, 1B, like maybe breaching one of the specific conditions attached to your registration, or breaking the advertising rules, the penalties are still significant. We're talking a fine of up to R$500,000 or imprisonment for up to 1 year. Still very substantial.
And it's not just fines and jail time, is it? What happens to the illegal products themselves?
The court doesn't have a choice there. Section 35(2) says the court must order that any liquor involved in illegal manufacturing or distribution be forfeited to the state, and any of those prohibited, unsafe substances must be destroyed. So the illegal goods are physically removed and eliminated.
And one last point on penalties, which seems vital for businesses. Section 36, imputed liability. This spreads the blame around.
It does. It's a critical concept for owners and directors. Imputed liability means that if someone working for the registered entity, say, a manager, an agent, even a regular employee, commits an offense under this act, then the principal person, like the owner or the company director, can be held equally guilty.
Even if they weren't the one who physically did it?
Yes, if 2 conditions are met. Either the owner actually permitted the illegal act to happen, or, and this is key, if the owner failed to take all reasonable steps to prevent the offense from happening in the first place. It puts the onus squarely on management to ensure their operations are compliant and their staff are properly trained and supervised. You can't just turn a blind eye.
That's a powerful tool for ensuring top-down responsibility. Okay, let's wrap up by looking at how the whole system hangs together. We've got national rules, but retail is handled provincially. How does the Act stop things from becoming a complete mess with 9 different sets of retail rules?
That's where Chapter 6 comes in, establishing the National Liquor Policy Council. Think of it as the coordinating body. It's chaired by the national minister responsible for trade and industry, and its members include the provincial MECs, the provincial ministers who are responsible for liquor licensing in each of the 9 provinces.
And what's its actual function? Is it just a talking shop?
No, it's meant to be more than that. Section 39 lays out its functions. It's the official forum for intergovernmental cooperation on liquor matters. They consult on national norms and standards, discuss policy alignment, review proposed legislation, both national and provincial, and try to ensure some level of consistency across the country. It's also supposed to help settle disputes that might arise between national government and the provinces, or even between provinces regarding liquor regulation. It's the formal mechanism intended to keep everyone pulling in roughly the same direction.
And looking at Chapter 7, the minister also has the power to make specific regulations, especially around health issues.
Yes, Section 41 is quite specific on that. The minister, importantly, after consulting with the cabinet member responsible for health, can make regulations about public health considerations. Specifically, they can prescribe exactly what kind of public health notices need to be displayed on registered premises. Think warnings about drinking during pregnancy, or the risks of excessive consumption and how they must be displayed. This ties directly back to that social responsibility objective we started with, using the regulatory power to ensure consumers get health information at the point of potential purchase or consumption.
We've certainly covered a lot of ground today with the Liquor Act 59 of 2003. It's really clear it's much more than just a simple rule book. It's this complex machine trying to manage an industry, using tools like BEE requirements and registration conditions for economic transformation, while at the same time acting as a pretty strict social control mechanism. Protecting minors, ensuring product safety, and backing it all up with those hefty penalties like the potential R1 million fine.
It absolutely is. And that brings us right back to that core tension, that inherent contradiction we identified at the beginning. We saw how Section 41 allows for mandatory public health warnings, and Section 13 requires businesses seeking registration to actually make commitments towards combating alcohol abuse. So maybe the final thought to leave with you, the listener, is this. When a law requires an industry to actively invest in mitigating the very harms its products can cause, does that fundamentally alter the ethics of that commerce? Or does it perhaps subtly just build the cost of managing social damage into the normal price of doing business? That's a really deep question embedded right within the structure of this act itself.